Yes, Mr.
My Lord, if IB was the high water mark of my learned friend's case so far as European law is concerned, Calderelli and Foy are clearly the high water marks of his domestic case. But before we deal with them, I venture to suggest it might be useful to look at the development of the various domestic statutes, which I've tried to summarise as best I can in the respondent's case. I should say we've tried to summarise as best we can in the respondent's case, beginning at memory stick page number 1423, that is to say, chapter 4 of our case. And perhaps I could, in conjunction with this, take your lordships and my lady to the respective provisions. We've set out everything, as far as we're aware of, which relates to what might be called modern extradition history. And we start at tab 63. We don't need to look at the contents of this. It's memory stick pages 1077 through to 1079, but it's the two pieces of legislation under chapter 6 and 7 Victoria, which enact the treaties signed in 1843 with the King of the French and with the United States.
It's the 1843 Act. Yeah.
I'm sorry?
It's the 1843 Act.
Yes, indeed. Yes, my Lord. Thank you. And then the first major piece of legislation catering for more than just bilateral arrangements was the Extradition Act of 1870, which appears at tab 64, commencing at memory stick page 1080. And the relevant sections we draw the court's attention to are section 10 on page number 1083, which is the first section which provides for alternative status of persons extradited, namely persons accused and persons convicted. And then if we go forward to page 1087 to section 26, the interpretation section, we see at the very bottom of the page, the terms conviction and convicted do not include or refer to a conviction which under foreign law is a conviction for contumacy, but the term accused person includes a person so convicted for contumacy. And then again, following on, the term fugitive criminal means any person accused or convicted of an extradition crime. From there, it's unnecessary to take your lordships to the provision itself. The 1881 Fugitive Offenders Act, which commences at page 1093, includes section 10, which is the genesis of the passage of time provision, although it does not expressly enact it. That is because it sets out two other matters, namely triviality and bad faith, which subsequently become the three.
I think you make this clear in your case, don't you?
I'm entirely, I very much hope so, my lord. I don't wish to waste your lordship's time.
No, you're not wasting time. But
in any way, but
just to give you a glimpse that we have actually read your case.
I'm deeply flattered, my lord. Section 8.3 at chapter 4.7 then is concentrating solely on the case, page 1425.
Yeah.
We set out section 8.3 of the 1967 Act, where the passage of time protection appears for the first time. Then, of course, the well-known speech of Lord Diplock in Carcass, we set out at the following paragraph, and then section 11.3 of the 1989 Act. And then the development into section 14 and the mirror image provision in part 2 of section 82 of the 2003 Act. And we make the point at chapter 4, paragraph 14, that despite amending the original formulation of section 14 and section 82 of the 2003 Act Parliament's chosen to maintain the distinction between persons accused and persons convicted, and the point in time at which the passage of time commences for each category of persons, so far as any application under the passage of time bar is concerned. Parliament has been consistent throughout that, the point we make in relation to section 68A as well. And gradually, the legislative shift drives out the entire concept of a contumacious conviction. It survived in section 19, subsection 2 of the Fugitive Offenders Act 1967. It survived for the purposes of a designated Commonwealth country or colony in section 35, subsection 2 of the 1989 Act. And it survived equally in Schedule 1 of that Act, which simply repeated, virtually word for word, the provisions of the 1870 Act so far as they related to bilateral arrangements with countries such as the United States. But as the shift grows to accommodate the Council of Europe members, for whom the 1989 Act was enacted, with the vital historic alteration that no longer did they have to provide a prima facie case based on admissible evidence according to the rules of evidence of England and Wales and or Scotland and or Northern Ireland. Instead, we have a much wider arrangement with a variety of countries under the aegis of the Council of Europe, where a prima facie case is no longer required. Convictions in absence were also dealt with in that legislation. Just before I turn to it, can I take your lordships to tab 66 in the authorities bundle at page 1112, the European Convention on Extradition Order 2001. And I'm sorry that this is not included in our documentation, but for your lordships' note, should your lordships and my lady wish it, the convention entered into force on the 13th of December 1957, despite the fact that, of course, the United Kingdom was one of the founding members and drivers of the Council of Europe. It was not until 1990 that an order in council was made under the provisions of the 1989 Act, bringing the convention into force, transposing it into domestic law. And it came into force on the 14th of May 1991. Thereafter, and I hope I can take this at a gallop, a order was made in 2001 replicating the 1990 order, but accommodating and consolidating the variety of countries which had acceded to membership of the Council of Europe following the disintegration of the Soviet Union and its hegemony. And that is how the 2001 order comes into being, dealing with its contents. Can I take your lordships to page 1114, Article 1? Again, the dual basis of jurisdiction for extraditions, persons accused or persons wanted for the carrying out of a sentence or detention order. And in particular, can I take my lords and my lady to page 1125, Schedule 2 of the order, to the reservations and notifications by the United Kingdom.
Sorry, which article?
Page 1125, my lord.
Schedule 2.
Schedule 2.
Schedule 2.
Yes. And here you see a reservation entered concerning a right to refuse to grant extradition requested pursuant to or for the purpose of executing a conviction or sentence pronounced against the person concerned in his absence from the proceedings in respect of which the conviction or sentence was pronounced. And thus it is that we turn to section 6, in particular subsection 2 of the 1989 Act, which is set out in your lordship's bundle on page 1197 and 1198 of tab 68. Section 6, subsection 1, as the court sees, sets out a series of specific protections, perhaps best summarised under the heading the political offence exception. Then there is section 2, setting out the general interests of justice test, which has to be met before a person convicted in absence can be returned. Note that section 6.2 does not purport to alter the status or the classification of that person. It simply provides him or her with the protection. And at subsection 3, we see the autrefois protection. And subsection 3 is of some importance to the submissions that I'm going to make about, in particular, the case of Foy. Subsection 4, incidentally, sets out the so-called specialty protection. And returning, if I may, to the text of our case, this is a new protection. It has not appeared in any previous extradition legislation, save and insofar as in the form of a deeming provision relating to contumacy. But there is no deeming provision available for the Council of Europe's many civil code member states which have criminal justice systems which involve convictions in absence, and that of course has been the position as we've gone on under Part 1 of the 2003 Act to deal with European Union member states. The remaining Council of Europe members fall now under Part 2. But this is an entirely new provision, and with that in mind, can I take the court to the case of Foy, please, at tab 23, which is at page 413 on the memory stick bundle. And on page 414, to summarise the facts, Foy was convicted in absence, jumped bail from his trial proceedings, was convicted in absence, came to the United Kingdom and automatically qualifies for a retrial. He was sought if your lordships will bear with me a moment. I'm so sorry, I've just lost my place.
That's all right, don't worry.
Thank you. In any event, he was sought as a person convicted in absence, and the issues were taken, the principal issue taken at page 415, although section 6, subsection 2 fell to be considered, the reality was that the principal issue taken was section 6, subsection 3, because he was sought as a person convicted. Counsel for the applicant in that matter put forward the argument that as a person already convicted, he must be able to rely on the plea and bar of autrefois convict. And as the court will see from page 415, it was accepted that by virtue of section 6, subsection 2, he could not submit, it would not be in the interests of justice to return him, because he had, as it were, the protection of a retrial in his presence. At paragraph 4, prior to 1989, Lord Justice Kennedy giving the government the judgment of the court, says how to categorise fugitives who have been convicted in their absence but who can, if returned, apply to have the conviction set aside is an old problem. And he goes through the history from Coppin onwards. And on page 416, some 8 lines down, counsel concedes that prior to 1989, this applicant had to be treated as a person accused by virtue of the deeming provision, but it's no longer there. In any event, to cut matters as short as I can, the judgment concludes on page 418. He is right, line 4 of the last paragraph, he's rightly regarded for the purposes of section 6.3 of 1989 as a person accused. That is because, if returned to France, he's entitled to have his conviction at Villefranche set aside. And the ratio of the court, with great respect to my learned friend's submissions, was this, that autrefois is a protection against double jeopardy. If he's entitled to have that original conviction set aside, there is no jeopardy. Jeopardy is renewable, but it's not double. And the reference to the case of Thomas, which was a domestic case, which involved a gentleman who was employed in Italy and returned from Italy together with his employer's money, was prosecuted in his absence in Italy. The Court of Appeal upheld his conviction in this jurisdiction on the basis that as there were no extradition relations with Italy at that point in time for political reasons, he was not in jeopardy of being returned there as a convicted person. So the most important sentence is perhaps the last sentence of this judgment so far as classification is concerned. The fact that until he applies to have his conviction set aside, he can properly be described as a person unlawfully at large after conviction is not determinative of the issue under section 6, subsection 3. So that is our submission so far as Foy is concerned. There was no reclassification, there was no suggestion on the part of the court that he was anything other than the person convicted, but he was not entitled to rely on section 6.2 as was conceded because the interests of justice test would not be met, or rather would be met so far as the requesting authority is concerned by the offer of a retrial, and he was not entitled to rely on section 6.3 because in fact, the annulment of his original conviction removed the double nature of any jeopardy that he was in. And, my Lord, whilst we have the authorities to hand, can I take your lordships to Biker, referred to by my learned friend at tab 28, page 474, two brothers, both the subject of conviction warrants under the 1989 Act, or conviction requests, I should say, under the 1989 Act. And paragraph 4, Mr. Justice Henrique is giving the judgment of the court. Two issues arise in this application. The first issue is triviality, that is to say, section 11.1, nothing to do with the passage of time, nor to do with the status of the applicants. And at 19 on page 477, the second issue that arises is one of jurisdiction. It's submitted that because the applicants have been convicted in their absence and sentenced in their absence, they cannot be committed to await the decision of the Secretary of State as persons accused, because having already been convicted and sentenced, the principle of autrefois convict would apply. And at paragraph 29, counsel for the applicant sought to make a distinction between the case of Foy and this particular case. In the case of these applicants, the convictions recorded against them are categorised as final by operation of Czech law. And at the bottom of the page, the court will see section 306A of the Czech criminal procedure, which of course is the same section which appears in the European arrest warrant in respect of this appellant. And at paragraph 35, having regard to that documentation, I'm plainly of the conclusion that this was not the final judgment, since the conviction should be set aside on return, and accordingly these applicants can be dealt with as persons accused, as the court decided in Foy. That, of course, is a case under the 1989 Act, and as my Lord Hodge observed this morning, things have rather moved on in terms of the 2003 Act. We agree with the appellant that Section 14 develops Section 11 of the 1989 Act. We agree that Section 20 develops Section 6, subsection 2 of the 1989 Act, but it develops it and modifies it in certain significant particulars. And I'll come to that in a little while, if I may, when we look at the case of Sonia and Istanek.
So what do you derive from BCAR, Mr. Hardy?
Well, I'm sorry, man, forgive me. We say it was wrongly decided. But that if it was correctly or may have been correctly decided, nonetheless,
You say things have moved on.
Things have moved on. I'm grateful for your Lordship's formulation.
Thank you.
And the reason things have moved on, and I don't need to take your Lordships to the Act itself, because I hope I can summarise it. As is pointed out in Sonia and followed in Istanek, and as is the subject of much elucidation by Lords Bingham and Hope in Cando Armas and Dabas, the reality is that the 2003 Act presents a rubric of procedure.
What of procedure?
A rubric, my lord.
Rubric.
It essentially abolishes judicial discretion, save in very limited circumstances. The passage of time discretion is one that survives, but the Section 6.2 discretion in the 1989 Act has been done away with by Section 20 and its mirror image Section 85 in Part 2.
Well, are we concerned about that?
Well, the constitution of this court, which granted permission, my lord observed, and my lady, Lady Black, sat as a member of that particular court, gave a direction that they expected Section 20, subsection 5 to be argued.
Yes. But, I mean, you accept that the discretion is in play when one comes to the passage of time.
Well, the discretion remains in play in that the court is enjoined to make findings of fact, and dependent upon those findings of fact, if it finds it either unjust or oppressive, which is essentially an exercise of discretion, in that its findings of fact may point it one way or another, may take it one way or another.
It's an evaluation of the facts. Whether one would properly call it a discretion, I think is questionable. I don't think
Maybe a
I
judgment
defer to your
better
Lordship.
way.
I'm sorry, my vocabulary has let me down. It's a fact assessment exercise, and depending upon the outcome of that assessment,
Well, it's a judgment made on the facts.
Yes,
I think
indeed.
that's a better way of
Yes.
putting it. Well, you have absolutely no need to apologise, because it was I who used the word discretion. Anyway, let's move on.
And insofar as the argument put forward by my learned friend is to the effect that a person should be treated as a person accused if he's been convicted, Section 20 is important because it says he can't.
Right.
Once you are in the channel of a conviction warrant, you go through the Section 2 exercise. That is to say, is the statement in the form required by subsection 5, and are the particulars sufficient to satisfy subsection 6. There then occurs consideration of whether or not an extradition offence is made out on the warrant, and as the court knows, by virtue of the operation of Part 1 of the Act, a framework list offence is defined as an extradition offence without more, in effect. There are a number of categories, but I don't propose to take the court through the exercise in any great detail, because it's long established and settled law that this is how the Act operates. The judge then goes on to consider the bars, and as my Lord Kitchen pointed out this morning, if the person is convicted, the court is directed to go to Section 20 and carry out the Section 20 exercise. And only, that's a 3-stage exercise. Was he or she there? If the answer is yes, go to Section 21. If the answer is no, did he or she deliberately absent him or herself from the proceedings? If the answer is yes, go direct to Section 21. If the answer is no, go on to consider subsection 5. Will there be a retrial? And will that retrial in particular, I draw the court's attention to subsection 8, the specific requirements attached to the retrial, which derive from Article 6 of the Convention, particular provisions of Article 6 of the Convention. If the answer is yes, again go to Section 21. If the answer is no, discharge. And
do you accept that subsection 6, it should be 21A?
No.
No, sorry.
No, not at all.
So you say it's correctly framed through?
It is correctly framed, and had Parliament wanted to cater in a different way for those convicted in absence, they could have legislated so as to amend Section 20, but have not done so. The division remains. As my learned friend quite rightly pointed out, the Anti-Social Crime and Policing Act of 2014 effected amendments to the Extradition Act. I hope I can be permitted, I hope a not too light-hearted observation, that one might expect to find amendments to the Extradition Act 2003, not in the far-off, remote geographical territories of the Anti-Social Crime and Policing Act of 2014, but that's where they come from.
But I am troubled by subsection 6, because that is the case where the person did not deliberately absent himself and is entitled to a retrial.
My Lord, no.
Is that not right?
I'm so sorry.
It's 3.
Yes.
Yes.
I think that's right.
Yes, that is right,
but-
my Lord. Yes, I'm so sorry.
But in
yes.
that particular case, one would think if one's drawing a distinction between the two categories of persons,
Yes.
where you're going to be thrown one way or the other, you'd think that in that case, one would naturally be thrown into...
Issues of proportionality and form, may I suggest, under Section 21A.
21A.
Or Section 19 and 21A.
Yes,
Um,
but it
well,
says section 20.
Again, my Lord,
Sorry, it says 21.
again, Parliament has not chosen to do that, and we say there is significance in that, and it would be beyond, with great respect, this court's scope to take a piece of legislation like this and say where Parliament has amended it substantively in at least 2 pieces of legislation in 2006 and 2014, added additional protections for persons accused, but not replicated those for persons either convicted or convicted in absence. It is not for this court to make good any
In other words,
imbalance or
you say
deficit.
that it has to be presumed that this was a conscious decision by Parliament not to...
Precisely so.
Right.
So with that, I hope not too overburdening tour of the legislation. Can I go to Calderelli?
Yes.
Could I just ask one question? If, having got to section 20, subsection 6, you're then sent to section 21,
Yes.
and you have what would probably normally be an Article 8 exercise under
Yes.
section 21, at that stage it would be correct, regardless of what the passage of time defence was, to have regard to the whole period of time from the point from the commission of the offence right the way through.
It's open-ended, my lord.
Yes.
In fact, it would be correct to have regard to a point in time before
Well, yes,
alleged commission of the
you'd be looking
offence.
at the development of family life.
Yes, indeed.
And the interference with it.
One is looking at a very broad picture.
Yes.
And we accept, to some extent, the criticisms levelled by our learned friends at courts which, as it were, have to resort to convention rights to try to supplement, as it were, the passage of time. But on the other hand, it can scarcely be said that these sections offend against convention rights because they are expressly catered for in the legislation.
Yes. So there may be two times when the court looks at passage of time.
Yes.
One under the earlier section 11, is it 4, D, and then supplemented by section 14, and then again under section 21.
Quite so, my lord, yes.
Okay.
Does that mean that the courts that have looked at this particular case already have erred because they put all that together, didn't they, and looked at the question only once?
Well, our last submission to this court concerns the powers available to it under section 33 of the Act. Neither does this court enjoy a discretion in terms of the disposal of the appeal. If it disposes the appeal one way, consequences must and do follow. If it disposes it the other way, similarly so. And there is no power to remit or what.
Right, but that doesn't really answer my lady's question, does it? I mean, she is inviting you to agree or contest the proposition that the courts below did not look at through the right prism.
The district judge described the case as one involving a very long passage of time. He looked at a long passage of time. Sir Wyn Williams, sitting as a judge of the High Court, did not criticise the district judge's approach in regard to that.
But it was a shorter passage of time than he could have looked at.
Well,
I wonder if that's right.
No,
in paragraph 39 of Sir Wyn Williams's judgment, he says at the end, on any view, the judge was fully aware of the very long delay between offending and the hearing before it, and specifically mentioned it as a factor against extradition.
Precisely so.
So in ground 2, which isn't really before us, but insofar as we're looking at the Article 8 exercise, the courts below have looked at the period from the offending onwards.
The courts have, and
In relation to Article 8.
Could I just draw your lordship's attention to page 1459, which is the judgment of the district judge.
Yes.
Deals with the claim made by the appellant that he gave documents to the police in 2005. Well, of course, if the approach of the lower courts was wrong in this case, then that might have been a factor to take into account. But we would submit on the basis of one has to be careful in dealing with fact-specific cases on a general basis, but given the balancing exercise required by the case of Chelinsky, which is specifically referred to by the district judge and taken into account under his Article 8 consideration. Going back then to, he states that he gave documents to the police in 2008. There was a trial in 2008. The evidence suggests the documents would have been lost or destroyed. If they were lost, as the requested person is entitled to a complete retrial, I'm entitled to presume under the principle of mutual trust and respect that the judicial authority would provide an Article 6 compliant trial that would take that potential unfairness into account in the requested person's favour. And the point we make is that there is nothing in the evidence given to the Magistrates' Court on behalf of or by the appellant, and indeed, as it were, on his behalf by his partner, which would engage that period of time prior to his conviction.
So Article 8 would not be engaged. Is that what you're saying?
No, Article 8 is engaged
Yeah.
freely, my lord.
Yes,
But in
right.
terms of the passage of time protection, section 14,
Oh, yeah.
if one is looking for injustice or oppression, there is no evidence which would support any such finding in the period between the commission of offences, that is to say from the 26th of November 2004, on to the conviction and him thereafter becoming unlawfully at large in 2008.
I think my lady's point was that they'd done it once, they hadn't done it under Article 8 again.
They did.
with
They
the
did, didn't they?
But they did, in fact.
1462.
Yes, indeed, my
One-
lady.
one-
I'm so
something-
sorry. Yes, my lady, yes.
Just
I'm
facts
sorry.
found relevant
Yeah.
to the balancing exercise at 1460 at the bottom, and then 1462 as well.
Yeah.
Yes, and your lordship see reference to the case of Chalinsky, where the then Lord Chief Justice, dealing with conjoined appeals in the Divisional Court, set out if I may use the word again, rubric exercise to carry out a balancing factor which either militates in favour of or against.
But on my specific
Article 8.
point, it's at 1462, there's an express mention
Yeah.
of the time right back to the start.
Yes, indeed. So it is considered, and as we say, you could go back beyond the actual commission of the offence itself. You look at the entire picture, if you like, of any factors that occur which may engage an Article 8 right
Yes.
over whatever passage of time is pleaded by the proposed extraditee, if I could call him or her that.
So stepping outside the circumstances of this case, if you imagine someone who is convicted in his absence, say 20 years after he has left the country in which the prosecution took place, and 25 years after the offences were committed, and in the meantime has not only established a family life, but that has various aspects, may have become a father, grandfather, and so on. How does that play into the assessment of Article 8? I mean, given
Well-
that the law, as you say, appears to say that you only take into account the period from the date of conviction.
Only for the assessment of injustice and or oppression under this particular provision.
Yeah.
There are additional protections within the Act itself.
So
And there is
Article 8
also-
could trump the protection, the statutory protection, or could trump the absence of the statutory protection.
Hypothetically, Article 8 could
Yeah.
overcome
Yeah.
the absence of the statutory protection under Section 14. There is also, my lord, a residual abuse of process
Yes, of course.
jurisdiction.
Yes, of course. Yeah.
If I may say so, that was not always the case under preceding legislation, because where the Secretary of State was responsible as the ultimate arbiter of whether a person should be extradited, as he or she was up until the coming into force of the 2003 Act, it was held by their Lordship's House that there was no abuse of process jurisdiction vested in the courts, because the Secretary of State was judicially reviewable in any event, and therefore an abuse of process jurisdiction was A, unnecessary, and B, not founded on any legal principles.
Yeah.
In the so-called NatWest 3 case, in which, if I may say so, historically Mr. Summers and I appeared together on the same side, the position was that the Divisional Court accepted unchallenged, and there has been no challenge to it since it's been endorsed on a number of occasions, that the removal of the Secretary of State from the scheme altogether meant that the court had its abuse of process jurisdiction restored. So there is that protection as well, which is available.
Yes, right.
And for that reason, we say first of all, there is no power in this court, with great respect, to amend de facto an Act of Parliament by making available an interpretation which is simply not linguistically available in the terms of the statute. Secondly, and in any event, that doesn't disadvantage a person convicted, absolutely, because he has other protections, he or she has other protections, including convention rights.
Right. Okay, well, that seems reasonably clear.
Yes.
Let's move
I
on.
was going to come to Corderelli, I'm so
Yes.
sorry.
No, not at all. No, don't apologise. Do come to it.
My Lord, we say Corderelli is entirely harmonious with the formula that we propose. And in short form,
Which tab is it?
I'm tab 34, my Lord, I'm so sorry. Memory stick page 600. Such is the nature of the extradition bar, my lady, my lords, if I may put it this way, that Mr. Summers and I found ourselves on the same side in this case as well.
Oh, well, that's a very happy circumstance.
So we are to some extent retreading old ground. But
Well, you can tread it fairly quickly then.
well, I will. The point in Corderelli is that there was no enforceable judgment because the appellant had already appealed against his conviction in Italy, which was accordingly set aside and unenforceable, and therefore he was properly treated as an accused person on an accusation warrant. That is, in substance, the ratio of the case. And I could perhaps deal better with it through submissions not by counsel, but instead through analyses by the High Court. And may I turn in that context to tab 61 at page 1013, the case of Imre, in which no doubt this court will be relieved to hear Mr. Summers appeared and I did not. So, I'm so sorry, my Lord, it's volume 4. First entry in volume 4. And Mr. Justice Mayles giving the judgment of the court on an appeal by Mr. Imre against the order of extradition made against him. Paragraph 2 sets out the appeal arises as a result of the fact that the appellant was convicted in his absence by the district court in Zsolnok in Hungary after the issue of the EAW, that is to say, after the issue of an accusation EAW, although his conviction is subject to appeal. In the light of this development, it submitted on his behalf that although the EAW was when issued an accusation warrant, 1, the appellant must now be treated as a person convicted in his absence for the purpose of deciding whether he should be extradited. 2, the EAW is invalid because it does not contain the information required in a conviction case. And 3, his extradition is barred by Section 20 of the Extradition Act 2003. Somewhat the reverse of the position in this case, it might be observed. At page 1017, at paragraph 21,
Yes.
the court sets out the distinction which we have concentrated on in our respective submissions before this court. And at paragraph 22, that is developed. Then at the bottom of page 1019, there is the heading Accusation and Conviction Warrants, the framework decision. And then there is an analysis of Lord Mance's judgment in Golachowski. And the change in the law, which was affected by the Bobby Dogie case, that change in the law being that whereas under Dabus, Lord Hope had said the contents of a European arrest warrant are self-contained and cannot be supplemented, the Court of Justice of the European Union said that Article 15 of the framework decision provided for the provision of further particulars, and those could be taken into account. And at paragraph 45, there is an analysis of Caldarelli on page 1022. Demonstrates that conviction by a court of first instance does not necessarily render the person convicted for the purposes of the framework decision and the Extradition Act 2003. I'm so sorry.
Paragraph are you?
45.
I'm so sorry.
45, thank you.
Paragraph 45, my lord. Do forgive me. I'm afraid I'm having to make my submissions confined to the passage of time. Can I invite your lordships to just read paragraphs 45 and 46? And then paragraph 47 in the light of that analysis of Caldarelli.
Yes.
And to cut matters further short, my lord, can I take you to Istanek, much criticised by our learned friends, but we say absolutely correct, in harmony with Caldarelli and in harmony with all other jurisprudence.
Tab?
Where that jurisprudence is correctly decided. Tab 43 at page 683, my lord. And Lord Justice Laws giving the judgment of a three-judge divisional court sets out at paragraph 3, the appellant had been convicted in the Czech Republic in his absence. He's entitled to seek and obtain a full retrial. No great formality is required. And then there is reference to the same section of the Czech Penal Code, 306A. And at 685, paragraph 6, it seems to have been, after he set out section 2 and its contrasting strands, paragraph 6, it seems to have been submitted before District Judge Wickham that the EAW was not a conviction warrant. She held that it was and that it complied with section 2 and was valid. It's now accepted on all hands that the EAW is properly described as a conviction warrant. The question which is, paragraph 7, the question which has emerged on this appeal is whether in the events which have happened, the appellant is in truth an accused, not a convicted person. And then the history of the case before the administrative court is set out. Section 306A is then set out. Mr. Justice Ousley adjourned the case on the 3rd of February 2011, that's at paragraph 8, and it was restored on the 2nd of March again before a three-judge court, by which stage other counsel had been instructed and provided skeleton arguments, and indeed the Attorney General had become involved, and there was a move to gather as much information as possible from Eurojust about the way in which these issues are approached across the various member states of the European Union. Paragraph 11 was commentary on the apparently conflicting authorities. Bikar at paragraph 12, Janiager at 13, Rizika at 15, and then Sonia at 17. And it's unnecessary for me to take this court to the judgment in Sonia. It is at tab 36, should the court wish to note that. Because the essence of Lord Justice Scott Baker's judgment in that case is set out here by Lord Justice Laws. And paragraph 16, as quoted, of the Senair judgment in paragraph 17 of this case, Isternek, on page 687, Lord Justice Scott Baker sets out the step-by-step exercise that is required in the case of a Part 1 warrant. And then at paragraph 17 of Lord Justice Scott Baker's judgment, the important section 20 criteria, it seems to me, come into play at the relative time. There was then a citation of Nichols, Montgomery and Knowles. And at paragraph 18, counsel for the appellant in that matter, as it seems to me, puts the cart before the horse. Seeks to extract questions that Parliament has set for to be dealt with under section 20 and make them issues that determine the nature of the warrant, whereas the legislation clearly sets out a step-by-step process. Then there is citation from Calderelli. And at paragraph 19, Lord Justice Laws continues, Mr. Justice Ouseley was inclined to consider Senair more consistent with the statutory framework than the three cases relied on for the appellant. And then Lord Justice Laws goes on to set out propositions which he says are determinative of the appeal. The first is that the 2003 Act has to operate in relation to warrants from different jurisdictions where the principles and procedures of the criminal courts often differ, both from each other and certainly, most of them being civilian jurisdictions, from criminal process in England. Consequently, he goes on at proposition 2, it's possible that what one state regards as an accusation case will another be treated as a conviction case. The material supplied by other member states of the European Union through Eurojust shows that there is no consensus across the European as to the approach to be taken within the EAW scheme to convictions in absence, where the individual enjoys an unqualified right of retrial. 3, it must be inherent in the scheme that our courts, in deciding whether the fugitive's extradition is sought on a valid EAW, will go on the basis of the statements in the warrant and will properly categorise the relevant facts according to the procedures and law of the requesting state. A citation from Calderelli and the now famous phrase that a trial in Italy is a continuing process, not an event. There appears to be a difference in the Czech Republic in that the event has come to a conclusion, we submit, although by virtue of section 306A of the Code, it can be reopened. Paragraph 28, the fifth proposition, I make no reference to the fourth, the existence of a right of retrial cannot be treated as a matter of law as systematically inconsistent with the fugitive being a convicted person. That is to apply one-size-fits-all approach, which is contradicted by the considerations I've already set out, and as Lord Justice Scott Baker observed in Senair, it's an approach which cannot sit with section 20 of the Act. And he also sets out this, which is a further explanation of section 306A from the Czech judge who originated the warrant. And it sets out the paragraph there, and the court will see the last sentence. Nevertheless, if the fugitive who's been convicted and sent here doesn't ask for reopening of the case, the judgment remains legally binding and enforceable, since the whole proceedings have been already took place and the judgment is already legally valid.
Well, I don't think Mr. Summers disputes that. I don't think Mr. Summers disputes that.
I accept that, but I draw my Lord's attention to that because the binding and enforceable formula, which we say is the correct formula to determine the status of a person for the proceedings under the 2003 Act, is there set out.
Yes. Right.
But my Lord, may I just mention two last matters? The first is this, that my learned friend invited the court to consider that a warrant could be an amorphous instrument which could change in its status from one form to another, or to accommodate further particulars under the Article 15 procedure in Golochowski. We draw the court's attention to the case of Zarkreski at tab 48 in the judgment of Lord Sumption, at tab 48, and I'll just give your lordships the pagination, if I may. The particular...
824.
I'm so grateful. 824, and in particular, can I draw your lordship's attention to Lord Sumption's judgment of paragraph 8, letter E. This is considered in Golochowski, but it's not held to be wrong by the court in Golochowski. And letter E, the validity of the warrant depends on whether the prescribed particulars are to be found in it and not on whether they are correct. It cannot be open to a defendant to challenge the validity of a warrant which contains prescribed particulars by reference to extraneous evidence tending to show that those statements and information are wrong.
Yes.
A warrant is either valid or not. It cannot change from one to the other over time, he concludes.
This was before Bob Dogie.
It was indeed, but the issue in Bob Yogi turns on Article 15 of the Framework Decision, which provides for the provision of further particulars and how far those particulars can go to supplement a warrant. Unless I have misunderstood it, Bobby Yogi is not authority for the proposition that a warrant can change from an A warrant to a B warrant, or an accusation warrant to a conviction warrant, or vice versa. Lastly, this, with great respect, the suggestion that Section 20 can reroute a person if it's found that he or she has the right to a retrial back to the start of the process, so that one has to look at a different warrant, or a warrant whose particulars are significantly changed to reflect an unaltered status, is, with great respect, simply wrong. The structure of the Act does not permit that. There is no warrant whatsoever for construing Section 20 as having that effect. And it runs counter, as Lord Justice Scott Baker pointed out in Sonaire, to the structure and procedural rubric, as we term it, of the Act. I think I've spared my lords and my lady half an hour.
No sparing. But anyway.
Can I assist the court any further?
Thank you very much. I think not. Mr. Swain?
My lord, my lady, I have nothing further to add.
Right. Now, Mr. Summers.
IB. This is an issue of European law. IB is abundantly clear. One, it isn't narrow. It isn't only concerned with Article 5, sub-Article 3, with no wider application to, say, Article 16, 18, 25, all those other articles that use the same phrase, or the domestic legislation that carries the same distinction. You know that from paragraphs 56 and 57 of IB. 56, if the sentence imposed in absentia is not yet enforceable, the surrender would serve the specific purpose of enabling the criminal prosecution to be conducted or the case to be tried. That is to say, surrender would be for the purposes of criminal prosecution. That's the general statement. Then moving to the particular, which is the situation envisaged by Article 5.3. The same emerges with even greater clarity from the opinion of the Advocate General. Paragraphs 47. This is it.
Could you give the MS number, please?
MS 50, 47, 48 and 49 deal and only deal with the issue of classification. I'll return to these paragraphs in a moment. Then and only then, once the issue of general application is dealt with, the opinion of the Advocate General being, at paragraph 50, you start as one, you become another. Consequently, he says at 51, he moves from the general to the particular. Consequently, the court should interpret Article 5.3 in the way that ultimately it does. This is no narrow interpretation concerned only with Article 5.3. In both instances, there is a general application or interpretation of the law followed by a particular application to Article 5.3. Neither, secondly, is IB permissive. EU law and the classification under it isn't somehow optional. The court must classify in accordance with the judgment of the court. But what's optional, or more accurately permissive, would then be, for example, the application of Article 5.3 to the facts of that case. So paragraph 60 of the judgment of the court, memory stick 62, having approached as a matter of jurisdiction Article 5.3 in the right way, it applies to such a person, the executing member state may make the surrender of the person in a situation such as IB subject to the conditions laid down in Article 5.3. Of course, it may not. All will depend on the facts. There the court is talking about the application to the facts. It's not talking about somehow EU law being permissive, optional, take it or leave it. But 3, the idea that IB is not concerned with classification is, with respect, nonsense. It's all it's concerned with. The court begins its discussion of classification at 49. It says there's only 2 conceivable situations. It ends it at 57, telling us which of those 2 classifications apply to a case such as this. As indeed was the Advocate General. Memory stick 50, paragraph 47. He's talking about ambiguity as to characterization of the arrest warrant. He records that Belgium and Poland had argued that somebody in IB situation, somebody in this appellant situation, is somebody who is being prosecuted. On the other hand, IB himself, Sweden, Germany, Austria, and the Commission have all taken the view that they are to be classified as executing a sentence. The Advocate General's opinion of it all was that both are right. To some extent, paragraph 48. I don't think, he says in paragraph 48, the warrant need necessarily be characterized as either one or the other. Rather, I believe that a warrant such as this falls within both. It depends on the timing and on the conduct of the person concerned. At 49, he makes the point that it starts life as one issued for execution of a custodial sentence. At 50 is his ultimate opinion. From the foregoing, it can be seen that the warrant which allows for the accused to be retried is formally a warrant for execution of sentence, which, once the person concerned has stated he wishes to be retried, becomes, in substance, a warrant for prosecution. And further down, he talks in terms about it changing. It changes the form of the arrest warrant. These decisions are all about classification. And fourthly, it was suggested that none of this is any assistance to the interpretation of Part 1. With respect, we fail to see how that can conceivably be so, given that Part 1 implements this framework decision. The CJEU speaks authoritatively as to the meaning of the framework decision, and Part 1 uses the same terminology as the framework decision. IB resoundingly favours the allowing of this appeal. If, on the other hand, this is solely an issue of domestic law, well, then I rely on 150 years of the common law, the avalanche from Coppin downwards. None of that has anything to do with deeming provisions. You know that because they haven't existed since 1989. so far as European states are concerned, and yet the common law has marched on relentlessly. Only Istenek has veered off course. And the submission that's been made to you today, to the effect that the absence of any deeming provision in the 2003 Act has somehow wiped out the concept of contumacy, is precisely the same one that was advanced by Mr. Hardy in the 1989 Act, when there was no deeming provision there, and has been roundly rejected by the courts down the years. Can I just correct, please, an impression you might have received from Mr. Hardy's run through FOI. FOI is at tab 23. Memory stick 413. FOI was a case where there was a right to apply for retrial. Extradition was properly sought and ordered, not as Mr. Hardy suggested, as a convicted person, but as an accused. Mr. Hardy's argument was that, in fact, he was properly to be categorised as convicted, and that argument was roundly rejected. It came alongside an argument, and you see it at page 416, that somehow this contumacy, the idea that people with retrials are categorised as accused, has been swept away because there's no deeming provision in the 1989 Act. So page 416, Mr. Hardy conceded that prior to 1989, people like Mr. Foy, Mr. Coppin, this appellant, should be treated as accused. That's in the middle of that paragraph that begins that, as Mr. Hardy points out. Then right at the bottom, begins his submission that he should now be treated somehow differently because he submits contumacy has been swept away. That was a submission that there was no deeming provision under the Act, and all this turned on deeming provisions. That was roundly rejected. The end result, we've been through Foy, the end result you see at the bottom of page 418, Mr. Foy is rightly regarded as a person accused. That is because if returned to France, he is entitled to have his conviction at Villefranche set aside. It follows that if charged, he would not be entitled to be discharged under any law regarding previous convictions. That's a reference to section 6.3 because that's what Mr. Hardy had put up as an alternative argument. And then this, the fact that until he applies to have his conviction set aside, he can properly be described as a person unlawfully at large, is not determinative. That is to say, it doesn't affect the position. He remains accused.
Well, not determinative means it is not of itself the answer. That doesn't mean it doesn't affect the position. It's a factor to bear in mind.
Mr. Foy remained accused, notwithstanding that his right to a retrial was one that was to accrue by way of
my only point is saying something is not determinative is not the same as saying it's irrelevant.
I understand, my lord, but it did not, on those facts,
Yes.
alter the court's assessment that Mr. Foy was accused. It is a feature of all retrial cases. It is always the case that you have to apply for your retrial, for it to accrue, often within a period of 8 days, 10 days upon surrender. It was a feature of Coppin, Foy, Bicar, Hewitson, NJ, Ruzicka, Rahman, Lewicki. All of those cases were cases in which until you made that application, technically you remained convicted. But the substance of the point, and this is the point made in Foy, is that inevitably that conviction will be set aside. If there's any doubt about this, can we go back, please, to IB? Because the position was the same there. It always is the same. Paragraph 57. given that the situation of a person who was sentenced in absentia and to whom it is still open to apply for a retrial is comparable to that of a person who is the subject of an EAW for the purposes of prosecution.
Sorry, which paragraph?
57. The court is entirely cognizant of the fact that the retrial hasn't yet accrued. It's one that IB has got to apply for formally in the fullness of time. He remains somebody properly categorised as being prosecuted. As I say, Coppin, Foy, Hewitson, Bicar, all the way down. Enforceability. I don't accept it's the right test. Caldarelli, paragraph 24, draws out those aspects of the framework decision that talk about finality. Finality is the test under the framework decision. That is the yardstick by which you measure whether a conviction is binding, going to be put into effect, or liable to be set aside as of right on surrender. It is, however, a dispute without a difference. The reality is they're the same thing, probably. If it's final, it's enforceable. If it's not final, it's not enforceable. And a conviction that is liable to be set aside automatically and as of right on surrender is not one that is enforceable. It won't be enforced. IB, paragraph 57. And to look only at the position that pertains before that application is formally made is wrong and nonsensical. IB's conviction was not enforceable, paragraph 56, because he had the right to apply for a retrial. That's the only thing that had changed in his case. Nothing else had supervened. And yet nobody suggested, including the court, that his sentence was enforceable in the sense that Mr. Hardy suggests. The idea that the requesting state determines categorization is wrong. The only authority which suggests it is Istanek. Remember, Istanek is a retrial case where, I think it was the Czech Republic's own evidence, confirmed that the judgment wasn't final, but the judge had issued a conviction EAW nonetheless. The High Court thought that was okay, based on a complete misapprehension of Caldarelli, paragraph 24 in particular. Lord Bingham was not there saying, let the issuing authority decide. Lord Mance says so in terms at paragraph 42. Caldarelli refers back to Zeza, which says so in terms at page 331. Ultimately, the idea that the issuing state decides is flatly contrary to IB. Romania had issued conviction EAW, it was wrong. On any view, this is an issue of EU law. There's an obligation on the UK court to ensure that the warrants it executes are in compliance with EU law. It cannot abdicate that responsibility to an issuing state. Changing status. Mr. Hardy submits that you enter a channel, even if on a basis that turns out to be inaccurate, that your status is fixed. Well, I'm sure the court will understand that we fundamentally disagree. Can I start with Mr. Hardy's suggested remedy? For Mr. Hardy, the only remedy for somebody sent down the wrong tube is a hope that the issuing authority will withdraw the warrant, will realise it's done it wrong and will withdraw. well, no doubt a forlorn hope, if he is right, that the issuing judicial authority gets to determine status. Why should it? Even under the old fixed view of validity that pertained in Zakrewski, that notion was not the complete picture. Paragraph 10, this court talks about withdrawal as being one potential remedy for somebody who is done injustice by an inaccurate EAW. But it goes on at paragraphs 11 to 13 to make clear that that's not the only remedy. Abuse also exists. That faultless abuse conceived by this court to do justice in that situation. Now, in addition, validity has morphed. What was thought to be static in Zakrewski is now known to be fluid. Bob Dodgy, paragraph 65, Goluchowski, in particular paragraphs 50 to 52, Lord Neuberger, who had joined with Lord Sumption in Zakrewski, paragraph 8, revisits it.
So, which was the MS reference for that, please?
Goluchowski, which is Authorities 3, tab 59, memory stick 971, paragraphs, in particular 50 to 52, but it all begins at about 44. Zakrewski had said validity is static. CJEU in Bob Dodgy had said no. An invalid EAW can become valid or vice versa by reference to extraneous information. And so in Goluchowski, this court revisited what it had said in Zakrewski.
Thank you.
So for somebody sent down the wrong tube, there are at least 3 potential safety valves. Withdrawal by the issuing state, abuse, which is a flexible remedy, which it would allow you by way of remedy to start again, or reconsidering validity under Goluchowski. The issue isn't, we anticipate, ultimately, whether there's a remedy, something to do about somebody sent down the wrong tube. It's whether IB says in terms, as we say it does, that somebody's status does change. Because if IB says that, then this court's got to find a remedy or a solution to an act that doesn't on its face permit somebody sent down the wrong tube to be taken out and pulled back to the beginning. IB, in our submission, is unambiguous. IB entered his extradition process as a person wanted for sentence execution. That took him into Article 5.1. He emerged from that with a retrial guarantee, and the court says in terms in paragraphs 56 and 57 that he is now comparable to a person who is being prosecuted. The court isn't there saying, in our respectful submission, that we have to bend Article 5.3 to make it fit somebody in his position. They are saying he is, because his sentence isn't enforceable, he is subject to now to surrender for the purposes of criminal prosecution. When you read that, 56 and 57, against what the Advocate General had said, there can be no doubt at all about what the court was saying. So back, please, to the Advocate General. Memory stick, page 50. We've looked at this briefly. It begins at 47. He's talking about classification. He records the competing arguments. Some countries thought it was prosecution. Some countries thought it was execution of a sentence. This is all how to categorize somebody once they've accrued a right of retrial. 50. He is formally a warrant for execution of sentence, which once he has stated that he wishes to be retried, becomes in substance a warrant for the purposes of prosecution. The Advocate General is talking about somebody's status changing. This transformation, he says, cannot entail a loss of any of the guarantees provided under the framework decision. On the contrary, he says, entry into play of Article 5.1, which seeks to provide a solution to the difficulties arising where decisions are rendered in absentia, changes the form of the arrest warrant. That is what the court was approving at paragraphs 56 and 57 of his judgment. It wasn't engaging in some expansive, false, unnatural interpretation of Article 5.3. So EU law tells us that somebody's status does change when they accrue a right of retrial. The issue for this court is how to accommodate that within the rubric of the 2003 Act, given what we have seen about Section 20. It's problematic. Section 20, subsection 6, doesn't on its face permit the court, the extradition court, to step back and now deal with that person as they must under EU law as a person accused. Is there therefore some other safety valve pursuant to Peppino, paragraph 47? Yes, there is, which is why I began with withdrawal, perhaps, but definitely validity. You look again at validity. Is this now a valid accusation, EAW? If no, discharge. If yes, start again. Or, if there's some problem with that as a juridical approach, abuse of process. So Konecny, paragraph 13. Is it fair, right, proper to now proceed onward as a conviction case? How do you protect the 4-month defendant that we have spoken about, whose EAW, if dealt with as a accusation EAW, would be entitled to be discharged? Should he carry on down the conviction tube, even though he is accused? Of course, he shouldn't. Article 8 is no panacea for that person. Article 8 is no panacea or substitute for Section 14 in any case. Article 8 focuses on somebody's family situation now and seeks to balance that against the public interest in extradition. It doesn't focus on or examine how that situation has changed over the years since the offence was committed. It doesn't seek to attribute responsibility for the delay that has occurred. It doesn't engage with the false sense of security that a defendant may have been engendered throughout all of that period. Somebody may well win under Section 14, but fail under Article 8 because his children have grown up and left home. And all he's left with is a bedsit in which he lives alone, and there's nothing particularly problematic about removing him from it for the purposes of extradition. And what about restoring to the person unfairly convicted, entitled to a retrial, his right to argue for him? Article 8 doesn't do that in any meaningful way. The authorities tell you that. What about Section 12A? The fact that there was a decision to proceed to trial in his absence says nothing at all about the procedural steps that now need to be taken in his presence. Witness confrontations, interviews, all of the usual things that go on in a pre-trial situation. What about validity? What about proportionality? What about temporary surrender? Is he to be cut out of all of those things? Article 8 provides no substitute for them. There has to be a proper safety valve that enables the court to stop the process and begin it again as a person accused. Finally, this case. This case is actually rather straightforward. This appellant was accused from beginning to end. His case involves no consideration of changing status or safety valves. He was wrongly categorised right from the start. We've only dealt with changing status because, of course, this court is going to want to deal with the situation more generally. But in this particular case, he should have been dealt with as a person accused right from the beginning, and he wasn't. And we understand that the respondent accepts that this appeal must be allowed if the certified question is answered in our favour. That is to say, that you decide that he ought to have been categorised as a person accused. The reason that we understand the respondent to accept that is because it accepts that this court possesses no power to remit for a rehearing. Mr. Konecny was entitled to an extradition hearing before a specialist judge who heard live evidence from him, from his partner, and applied the correct legal principles to the evidence that he heard and the evidential personal assessments that he made of it. None of that occurred. It's not possible to restore this particular appellant to the position he should have been in under the scheme of the Act. It's another straitjacket. It's not possible to restore him to a hearing before a judge without, for example, the judge's assessments being coloured by a view of him as a convicted, dangerous recidivist by reason of his unfair and unwarranted conviction. And those are findings that infected the judge's assessment, both of Section 14, look at pages 1454 and 1459, and Article 8, for what that was worth, page 1462. The judge approached both those decisions on the basis that he was convicted, he had been sentenced to a very significant term, and he was a dangerous recidivist. Of course he was going to answer Article 8 in the way that he did. He was approaching it on a false basis, and nobody can put this appellant back in the position he should have been had he been properly treated from the outset as a person accused. The High Court regarded it as arguable that a different result could have ensued. It doesn't certify academic questions. But if, contrary to all of that, this court is minded to assess the merits of his case for itself without the assistance of having heard live evidence, well then we say on the whole of the period that this was a case, if approached through the lens of an accusation, that ought to have engaged Section 14. Mr. Konecny is aged 58, his partner is aged 60. You're talking about events 10 to 13 years ago in 2005 to 2008. He says, his proof, paragraph 19, that he has lost evidence. That happened in 2015. That's injustice. He settled in the UK in 2007. He says, his partner confirms, that that was at least in part to escape domestic violence. That's oppression.
This is all in his statement, and I'm afraid your time's up, Mr. Summers.
Then can I just say two more words?
Yes.
Culpable delay. There was no explanation for any of this delay. Like Rahman, this was an arguable Section 14 case, but this court can't restore this appellant to his arguable Section 14 argument, unless I can assist further.
Thank you very much indeed.
My Lord, I'm very sorry to ask your leave to deal with the point of detail. I'm so sorry.
I think Lord Lloyd-Jones has a question for Mr. Summers.
That's all right. Mr. Summers, can you help me on this? If you're right, can we say it's Act clear in your favour?
Yes. Yes, IB is that clear. If I'm wrong, and there's ambiguity about IB, then I invite you to refer.
Thank you.
Yes,
I'm so
yes,
sorry
Mr.
to delay you. A point
not
of
at all,
detail.
Mr. Hardy.
If I inadvertently conveyed the wrong impression about Foy, I do apologise. I would be mortified if I left that impression uncorrected. Of course it is an accusation
Well, we want to
case.
spare your mortifications.
So, of course it is.
Of course it is an accusation case. It's
Accusation
plain
case.
on the face of the judgment, yes.
Yeah.
Thank you.
Right, thank you very much indeed. We are very grateful for all those clarifications and for the submissions that have been so helpfully made. And of course, the gratitude extends to those who didn't participate, but nevertheless were very active, no doubt, behind the scenes. We reserve our judgment and deliver it in due course.